Constitution. Introduction. The Indian Constitution is unique in its content and spirit. The salient features of the Constitution are as follows. First, lengthiest written Constitution. Second, blend of variety and flexibility. Third, federal system with a unitary features. Fourth, parliamentary form of government. Fifth, independent judiciary. Sixth, single citizenship. Seventh, emergency provision. Structure. The Indian Constitution originally consisted of 395 Act, 22 parts, 8 schedule. But after the Constitution 104th Amendment Act 2003, the Indian Constitution consists of 448 arts, 25 parts and 12 schedules. Preamble. The preamble to the Constitution is based on the objective resolution drafted and moved by Pandit Nehru and adopted by Constitution Assembly. It runs as follows. We, the people of India, having solemnly resolved to Constitution India into a sovereign, socialist, secular, with the people of India having solemnly resolved to Constitution India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens. First, justice, social, economic and political. Library. Second, liberty of thought, expression, belief, faith and worship. Third, equality of status and of opportunity. Fraternity, assuring the dignity of the individual and the unity and the integrity of the nation. In our Constitution Assembly, this 26th November 1949, do hereby adopt, intact and give to ourselves this Constitution. Purpose of the preamble. The preamble to the Constitution is a key to open the minds of the makers and shows the general purpose for which they made the several provisions in the Constitution. Preamble serve the following purpose. First is disclose the source of the Constitution. Second, it laid down the date of commencement of the Constitution. Third, it set out the right and freedom which the people of India wishes to secure for themselves. Fourth, it declared the nature of the government. Question 1. Whether preamble is the part of the Constitution? Answer. In the case of Kesavanand Bharati versus State of Kerala, the Supreme has held that the preamble is a part of the Constitution. Preamble is of extreme importance and the Constitution should be read and interpreted in the light of a grand and a noble vision expressed in the preamble. However, two things should be noted. First, the preamble is neither a source of power to legislature nor prohibition upon the power of the legislature. It is not judicial, not enforceable in court of law. Supremacy of Constitution. For a federal constitution, there should be supremacy of the Constitution. At the time, nature of Indian Constitution. The Constitution is of two kinds. Unitary. In a unitary constitution, the power of the government are centralized in one government. The states of provinces are subordinates to the center. Second, federal. In federal constitution, there is a division of power between the federal and the state government, and both are independent in their own spheres. Phrases. The American Constitution universally regarded as an example of the federal constitution. Characteristics of a federal constitution. First, a written constitution. For a federal constitution, it is a mandatory that there should be a written constitution. Second, dual government. In case of federal constitution, there is system of dual government, one at center and another at state. Third, supremacy of constitution. For a federal constitution, there should be supremacy of the constitution at the time of the exercise of power by three organs of the government: legislative, executive and judiciary. All functions are subordinate and controlled by the constitution. Fourth, contribution of power. Federalism means the distribution of power of the state among a number of coordinate bodies, each originating in and controlled by the constitution. Rigidity. Rigidity is one of the basic essential of a federal constitution. It highly depends on the process of amendment. Independent judiciary. There should be an independent judiciary having authority on other organs. In a federal constitution, the court judiciary has the final power to interpret the constitution. Finally, it should say that the judiciary is the guardian of the constitution. Conclusion. Finally, it can be said that the Indian constitution is neither purely federal nor purely unitary, but a unique combination of both the aspects. Peculiar features of Indian constitution. First, mode of formation. Second, position of the states. Third, citizenship. Fourth, residuary power. Fifth, the lengthiest constitution in the world. Meaning of state. Art 12. The state includes the first, the government and Parliament of India. Second, the government and legislature of each of the states. Third, all local and other authorities within the territory of India. Second, under the control of the government of India. All the fundamental rights are available against the state with a few expectations. Some case law. Electricity is a board within the meaning of Article 12. University, income tax department, corporation when deemed to be state. Ajay Hasiya versus Khalid Mujib. If the entire share capital is held by government, financial assistance is provided by the government to meet the entire expenditure. When corporation enjoy a monopoly status, when the state is having deep and pervasive control over the affair of the corporation. If the corporation is discharging public function, corporation acting as an agency instrumentally of the government. R.D. Shetty versus India Reporter. Stock exchange is not a state because it is independent from the government control. Satish Naik versus Cochin Stock Exchange Limited. Fundamental right. Introduction. The aim of fundamental right Fundamental right. Introduction. The aim of fundamental right is that certain elementary rights such as the right to life, liberty, freedom of speech and freedom of faith and so on should be regarded as inviolable under all circumstances, and that the shifting majority in legislature of the country should not have a free hand in interfering with the fundamental right. The fundamental right is called the Magna Carta of India, a right of equality. First, equality before law, Art 14. Second, prohibition of discrimination on the ground of religion, race, caste, sex or place of birth, Art 15. C. Equality of opportunity in marriage, public employment, Art 16. Abolition of untouchability, Art 17. Abolition of title, Art 18. Right to equality. Equality before law. Art 14 say that the state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. Analysis. Art 14 uses two expressions. First, equality before the law, and the second, equal protection of the law. Equality before law. This concept is taken from British Constitution. The concept of equality does not mean absolute equality among human beings, which is physically not possible to achieve. It is a concept implying absence of any special privilege by reason of birth, creed or the like in favor of any individual, and also the equal subject of all individual and classes to the ordinary law of the land. In the word of Dr. Jennings, equality before the law means that among equal, the law should be equal and should be equally administered, that like should be treated alike. Rule of law. The guarantee of equality before the law is an aspect of what Daisy call the rules of law in England. It means that no man is above the law and that every person, whatever he is, rank to condition, is subject to the jurisdiction of ordinary court. Daisy, the rules of law has three distinct meanings. First, supremacy of the law. Second, equality before the law. Third, the constitution is the result of the ordinary law of the land. Second, equal protection of the law. The concept is taken from American Constitution. This has been interpreted to mean subjection to equal law applying to all in the same circumstance. It only means that all persons similarly circumstance shall be treated alike both in the privilege conferred and liabilities imposed by the law. Equal law should be applied to all in the same situation, and there should be no discrimination between one person and another. The word any person in Art 14 of the Constitution denotes that the guarantee of the equal protection of law is available to any person, which includes any company or association or body of individual. The protection of Art 14 extends to both citizen and non-citizen and to natural person as well as legal persons. The equality before the law is guaranteed to all without regard to race, color or nationality. Corporation being juristic person are also entitled to the benefit of Art 14. Test of reasonable classification. While Art 14 forbids class legislation, it permits reasonable classification of person, object, and transaction by the legislature of the purpose of achieving specific end. But classification must not be arbitrary, artificial, or abusive. It must always rest upon some real and abstractional distinction bearing a just and reasonable relation to the object sought to be achieved by the legislature. Classification to be reasonable must fulfill the following two conditions. First, the classification must be founded on an intelligible differentia which distinction person of things that are grouped together from other left out of the group. Second, the differentia must have a rational relation to the object sought to be achieved by the act. K. Thimmappa versus Chairman Central Board of Director SBI and Ramkrishna Dalmia versus J. Tandulkar. New concept of equality. Protection against arbitrariness. In E.P. Royappa versus State of Tamil Nadu, the new concept of equality in the following word. Equality is a dynamic concept with many aspects and dimension and is cannot be described, cabinet and confined within traditional limit from a positivistic point of view. Equally is antithesis to arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic while the other to the whim and caprice of an absolute monarch. Where an act is arbitrary, it is implicit in it that it is unequal both according to political logic and constitutional law, and is therefore violative of Art 14. Expectation to the equality before law. Art 361. Of the Art 361 of the Constitution permit the following expression to these rules. First, the President of the government of a state shall not be answerable to any court. Second, no criminal proceeding whatsoever shall be instituted or continued against the President or Governor in any court during his term of office. Third, no civil proceeding in which relief is claimed against the President or the Governor of a state shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity. Provision of discrimination on a certain ground. Art 15. Provide that the state shall not discriminate against any citizen on ground only of first religion, second race, third caste, fourth sex, fifth place of birth, or seven any of them. Art 15. Provided that no citizen shall be on above ground subject to any disability, liability, restriction or condition with regard to first access to shop, public restaurant, hotel and place of public entertainment, or B. The use of wells, tanks, bathing ghats, roads and place of public resort maintained wholly or party out of state fund or dedicated to the use of the general public. Expression Art 15 3 4 and 5th contain expression to the general principle laid down under Art 15 first and second. Nothing in the article shall prevent the state from making any special provision for women and children. Second, nothing in the article shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizen or for the scheduled caste. Third, nothing in the article shall prevent the state from making any special provision by law for the advancement of any social and educationally backward classes of citizen or for the scheduled caste or the scheduled tribes in so far as such special provision relate to their admission to individual educational institution including private educational institute whether aided or unaided by the state other than the majority educational institution. Equality of opportunity in matters of public employment. Art 16. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall on ground only of first religion, second race, third caste, fourth sex, fifth descent, sixth place of birth, seven residence or at any of them be ineligible for discriminated against in respect of any employment of office under the state. Exemption. First, nothing in the article shall prevent Parliament from making any law prescribed in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory and a requirement as to residence within that state or union territory period to such employment or appointment. Second, nothing in this article shall prevent the state from making any provision for the reservation of appointments or post in favor of any backward class of citizen which in the opinion of the state is not adequately represented in the services under the state. Third, nothing in this article shall prevent the state from making any provision for reservation in a matter of promotion with consequential seniority to any class or classes of post in the service under the state in favor of the scheduled caste and the scheduled tribes which in the opinion of the state are not adequately represented in the service under the state. Fourth, nothing in the article shall affect the operation of any law which provided that the incumbent of an office in connection with the affair of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to particular demo, denomination. Abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. The term untouchability is not defined under the Constitution. However, it refers to the social disability imposed on a certain class of person by reason of their birth in certain caste. However, it does not cover social boycott of a few individual. Abolition of titles. No title not being a military or academic distinction shall be conferred by the state. Second, no citizen of India shall accept any title from any foreign state. Third, no person who is not a citizen of India shall while hold any office of profit or trust under the state except without the consent of the president any title from any foreign state. Fourth, no person holding any office of profit or trust under the state shall, without the consent of the president, accept any present emolument or office any kind from or under any foreign state. Right to freedom. Article 19. Define six freedom. First, freedom of speech and expression. B, freedom of assembly. C, freedom to from association. D, freedom of movements. E, freedom to reside and to settle. Freedom of profession, occupation, trade or business. These six freedoms are, however, not absolute and subject to reasonable restriction, which are as follows. First, security of the state. Second, friendly relation with the foreign state. Third, public order. Fourth, decency and morality. Fifth, contempt of court. Sixth, defamation. 7, incitement to an offence. 8, sovereignty and integrity of India. Judicial pronouncement on right to speech and expression. Meaning 19(1)(a), meaning of freedom of speech and expression. The freedom of speech and expression means the right to speak and to express one's opinion by word of mouth, writing, printing, picture or in any other manner. It includes publication also, which included inherent freedom of press. The liberty of circulation is vested in liberty of publication. Second, right to know. The fundamental right principle involved there is the people right to know. Third, in Prabhu Datta versus Union of India, Supreme Court held that the right to know news and information about the functioning of the government is included in the freedom of press. Fourth, the Union of India versus Association for Democratic Reform. Supreme Court held that people have right to know about the candidate before voting. Thus, the law preventing the election commission from asking for the candidate wealth, asset, liabilities, education, and other such information is invalid. In Tata Press Limited versus MTNL, the Supreme Court held that commercial speech, advertisement, is a part of freedom of speech and expression. UA sorry protection in respect of conviction for offence. Ex post facto law. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater. Than that which might have been inflicted under the law in force at the time of the commission of the offence. Double jeopardy. No person shall be prosecuted and punished for the same offence more than once. The protection under his clause is available only in proceeding before a court of law or a judicial tribunal. In other words, it is not available in proceeding before departmental or administrative authority. Self-incrimination. No person accused of any offence shall be compelled to be a witness against himself. It extends to both oral and documentary evidence. It extends to only criminal proceedings and not to civil proceedings. The benefit is available only when all the following conditions are satisfied. Person must be accused of an offence. There must be compulsion to be witness. Such compulsion should result in his giving evidence against itself. Right to life, personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. In Maneka Gandhi versus Union of India, the court has given the widest possible interpretation of personal liberty. Thus, Art 21 required the following condition to be fulfilled before a person is deprived of personal liberty. There must be a valid law. The law must provide a procedure. The procedure must be just, fair and reasonable, ensuring natural justice. Right to life includes within its ambit the right to live with the human dignity. The Supreme Court held that the right of life define only not only physical existence but the equality of life. Judicial pronouncement on right to life, personal liberty, right to travel abroad, right to livelihood, right to shelter, right to privacy. In PUCL versus Union of India, the Supreme Court held that telephone tapping is a serious invasion of an individual right to privacy, which part of the right to life and personal liberty, right to health and medical assistance, right to die, not a right to life, protection of ecology and environmental pollution, right to education under Art 21A, prisoner right. The court held that if the prisoner died due to beating by police officer, his family is entitled to compensation. a right to free legal aid, a right to speedy trial, right against handcuffing, right against delayed execution, a right to food, a right to marriage, right to reputation, right to die. In case of Jain Kaur versus State of Punjab, the constitutional bench of a Supreme Court held that a right to life under Article 21 does not include right to die.